want to see Congress pass laws that will help reduce crime without infringing on the rights of law-abiding citizens. But public safety concerns must be addressed in ways that are lawful. This rule is not.
There is a difference between states deciding how they want to regulate any number of things versus stripping people of their rights to self-defense.
This is not a gun decision.
No.
It's not. This was not decided on Second Amendment grounds.
The government may not regulate individuals' possessions of weapons for self-defense.
2 cases challenging the NFA and its restrictions on short-barrel rifles were seeking Supreme Court review. And now we have the court's answer, which is not great because, like the machine gun ban challenges, the Supreme Court has decided to deny immediate review to these SBR cases, meaning the constitutional questions surrounding these restrictions remain unresolved. What makes this development genuinely significant is how the petition focused on how the Supreme Court finally needed to step in to correct lower court confusion and defiance on what type of arms are protected under the Second Amendment's text. Why recently we got a response from the Trump administration where they argued the Supreme Court should deny review to these cases because they believed the NFA has at least some circumstances where it's valid and therefore should survive a facial challenge. How even more interestingly, they also argued that the underlying question on whether or not SBRs are arms and therefore protected is a question that should be answered in a different case, with the Trump DOJ calling for the Supreme Court to take up a state AR-15 ban to further outline that topic rather than this SBR challenge. And the reason today, we got the response and answer from the Supreme Court where they denied review to both of these SBR challenges, though this issue is not done yet. Once you understand why, for those not aware in this case, the Rush challenge was a challenge to a possession issue where the individual was possessing an unregistered SBR in violation of the NFA after an officer saw that Mr. Rush, who didn't have a driver's license, pulled into a driveway with his truck and walked into the courthouse across the street. How the district court on review denied the motion, concluding that SBRs are dangerous and unusual firearms and therefore not protected by the Second Amendment, which was then appealed to the Seventh Circuit, who on review affirmed the lower court's ruling relying on the Supreme Court's precedent in U.S. v. Miller. And what it means that despite the denials in these cases, the NFA issue is not yet over because there are other cases currently moving in the lower courts which are challenging the NFA based on the new $0 tax change that happened in recent legislation, where those challenges are leveraging the recent congressional changes to the zero tax on NFA, items like SBRS and suppressors trying to expand upon that to eliminate all remaining restrictions. You'll realize even though these 2 cases were denied review by the Supreme Court, there are other challenges which may be stronger that are still moving through the system, while we keep our eyes on the Viramontes state rifle ban case coming out of Illinois and also the Duncan, California magazine ban cases, which survived another conference and have been relisted once again, possibly indicating that if the Supreme Court had zero interest in those rifle ban and magazine ban cases, they could have simply outright rejected them like they did with these NFA challenges. Something significant just happened at the Supreme Court that affects millions of gun owners and constitutional questions that have been pending for years, and the implications reveal how the court is strategically choosing which Second Amendment cases to hear. 2 cases challenging the NFA and its restrictions on short-barrel rifles were seeking Supreme Court review. And now we have the court's answer, and it's not what Second Amendment advocates were hoping for. Like the machine gun ban challenges that were recently denied, the Supreme Court has decided to deny immediate review to these SBR cases. So let's break down exactly what happened, why it matters, and what happens now going forward with these constitutional challenges. Now, as mentioned, in this analysis we're examining a very important case and challenge that was in front of the Supreme Court. It's actually 2 cases dealing with the SBR restrictions under the NFA. These cases, U.S. v. Rush and then also the Robinson challenge, are challenges to the NFA and its SBR restrictions. These challenges asked for the Supreme Court to step in and find that the NFA's restrictions are unconstitutional under the Second Amendment. The petition also focused on how the Supreme Court finally needed to step in to correct lower court confusion and defiance on what type of arms are protected under the Second Amendment's text. Recently, we got a response from the Trump administration, and in their response, they argued that the Supreme Court should deny review to these cases because they believe the NFA has at least some circumstances where it's valid and therefore it should survive a facial challenge, and any facial challenge should fail. And even more interesting, they also argued that the underlying question on whether or not SBRs are arms and therefore protected is a question that should be answered in a different case. The Trump DOJ called for the Supreme Court to take up a state AR-15 ban to further outline that topic rather than this SBR challenge. Well, today we got the response and answer from the Supreme Court, and they have denied review to both of these SBR challenges. However, this issue is not done yet, so we need to talk about what happens in these challenges going forward and what happens with this constitutional issue also going forward. Now, for those not aware, in this case, the one we're going to focus on is the Rush challenge. It was a challenge to a possession issue where the individual was possessing an unregistered SBR in violation of the NFA. So essentially, in February of 2022, an officer saw that Mr. Rush, who didn't have a valid driver's license because it had been revoked, pull into a driveway with his truck and walk into the courthouse across the street where he was making a court appearance. Now, after leaving the courthouse, he walked across the street and went into a nearby apartment complex where his sister lived. About an hour later, his sister left the apartment, got into his truck, and started to drive away. Now, the officer decided to stop the truck, asked his sister to call her brother Mr. Rush, and the officer spoke with him on the phone. And Mr. Rush admitted that he did drive the truck to that location and that he would come out and talk to the officer. Now, while that was happening, the officer also looked into the vehicle and saw what he thought was marijuana in the center console, and because of that, the officer began to search the truck. Now, Mr. Rush arrived about that time, and when he arrived at the vehicle, he opened up one of the truck's back doors and reached in to grab something. He was detained, arrested, and later when they searched the vehicle, they found an SBR on the floorboard of the truck. And Mr. Rush admitted to the officer that he intended to grab the rifle and then run away. Now, because of this, Mr. Rush was charged with possessing an illegal SBR in violation of the NFA. Now, Mr. Rush argued that the NFA's registration and tax requirement restrictions infringe on his Second Amendment rights, and therefore those charges should be dropped. The District Court on review denied that motion, concluding that SBRs are dangerous and unusual firearms and therefore not protected by the Second Amendment. This was then appealed to the Seventh Circuit, who on review affirmed the lower court's ruling, relying on the Supreme Court's precedent in U.S. v. Miller. The Seventh Circuit found that Miller still remains controlling precedent and that the NFA's restrictions are consistent with the historical firearms traditions in the United States. This then led Mr. Rush to seek Supreme Court review, and in his petition to the Supreme Court, he asked for them to reverse that lower court ruling and strike down these NFA SBR restrictions. Now, like mentioned, the Trump DOJ originally decided to waive the right to respond to the petition, but the Supreme Court ordered that the Trump DOJ file a response. And in that response, the Trump DOJ argued that the petition should be denied because the NFA is facially constitutional. They argued there are some valid applications of the NFA when it comes to the Second Amendment context, and therefore it survives any facial challenge. They also argued that this case is not the proper case or vehicle for reviewing the broader question about what are protected arms. They argued instead the Supreme Court should take up a state rifle ban case to answer that question, but not this SBR challenge. Now, Mr. Rush, in response to that, stated that the court's precedent makes clear beyond doubt that the Second Amendment's plain text extends prima facie to all instruments that constitute bearable arms. Yet, the Seventh Circuit's panel below denied that the NFA's registration and taxation requirements for SBRS even implicated the Second Amendment's plain text. When lower court's Second Amendment jurisprudence deems ordinary long arms to fall outside the text of the Second Amendment altogether, that is a sign that the jurisprudence has taken a dangerously wrong turn. The Supreme Court should therefore intervene. In Mr. Rush's response, they started by pointing out how far lower courts have gone to twist Bruen and other Supreme Court precedent to protect these types of Second Amendment violations. He concluded by stating that this case presents the court with an opportunity to address and resolve one or more of those questions in the context of federal law that restricts the possession of common firearms that no one can plausibly claim are unusually dangerous or especially susceptible to criminal misuse. Therefore, the Supreme Court should grant the petition for hearing. Now, despite that argument, as mentioned today, we got the answer from the Supreme Court in their order list, and the Supreme Court has decided to deny review to both the Rush case and also another SBR case called the Robinson case. Now, that is not entirely surprising that they denied review to these NFA SBR cases. The court typically will try to avoid these types of issues. Also, we saw recently that the Supreme Court immediately denied review to a machine gun ban case which dealt with similar constitutional questions, and they did that after it went to conference. So many anticipated that these NFA challenges would suffer the same fate, and that's exactly what happened. However, another interesting development is that the Vera Montez state rifle ban case coming out of the state of Illinois, that challenge and also the Duncan, California magazine ban cases survived another conference and they have been relisted once again. Now, that might mean absolutely nothing. It could mean simply that they're just being pushed out because they're going to be denied down the road and maybe someone is wanting to write a dissent. But also, it could indicate that if the Supreme Court had zero interest in those rifle ban cases and the magazine ban cases, they could have just simply outright rejected those cases like they did with these NFA challenges. So there may be a silver lining with seeing these NFA cases get rejected immediately, that maybe the other cases dealing with rifle bans and magazine bans have a better chance. Now, despite the denials in these cases, the NFA issue is not yet over. There are other cases currently moving in the lower courts which are challenging the NFA based on the new $0 tax change that happened in recent legislation. Those challenges are potentially stronger because they are leveraging the recent congressional changes to the zero tax on NFA items like SBRs and suppressors, and they're trying to expand upon that to eliminate all of the remaining restrictions. So even though these two cases were denied review by the Supreme Court, there are other challenges which may be stronger that are still moving their way through the system. But unfortunately, these two NFA SBR challenges were denied review by the Supreme Court today. But again, not all hope is lost. We will now keep our eyes on the other NFA challenges that are still in the lower courts trying to leverage the $0 tax change, and also on the rifle and magazine ban cases that have been relisted by the Supreme Court. And we're going to see what does the Supreme Court want to do with those challenges. Are they maybe going to take up the arms ban question in one of those cases, like the rifle ban case similar to what the Trump DOJ called for in this Rush and Robinson challenge, dealing with the SBR restrictions? The strategic calculation here is fascinating. The Supreme Court appears to be carefully selecting which Second Amendment cases it wants to use to establish broader precedent. By denying these NFA challenges while keeping rifle and magazine ban cases alive on the docket, the court may be signaling that it prefers to address the fundamental question of what arms are protected in the context of more commonly owned firearms. The Trump DOJ's position is particularly noteworthy because it suggests the administration believes the constitutional analysis should start with more clearly protected arms like rifles before moving to address short-barrel configurations. This could be a strategic approach to building precedent incrementally rather than tackling everything at once. For gun owners and Second Amendment advocates, this denial is disappointing but not necessarily devastating. The fact that other NFA challenges are still moving through lower courts means the issue will eventually return to the Supreme Court, potentially with a stronger factual and legal foundation. The $0 tax change fundamentally altered the government's justification for NFA restrictions. If the tax was supposedly a revenue measure, its elimination to zero undermines that rationale. The remaining registration requirements would need to stand on their own constitutional footing, which could prove difficult under Bruen's historical analysis framework. Additionally, the continued relisting of rifle and magazine ban cases suggests the Supreme Court may be preparing to take a major Second Amendment case that could establish clearer standards for what arms receive constitutional protection. If the court rules broadly on that question, it could create precedent that effectively resolves the SBR issue without needing to take those cases directly. The lower court's continued resistance to Bruen and their creative interpretations to uphold gun restrictions demonstrates why the Supreme Court may eventually need to intervene more forcefully. The Seventh Circuit's conclusion that SBRs fall outside the Second Amendment's text entirely seems difficult to reconcile with Bruen's framework, but the Supreme Court has chosen not to address it at this time. That's it for today, folks. See you in the next video.